As I mentioned very briefly earlier, this panel is on administrative monetary penalties, and I mentioned our intervention in the CCF in a case called Gandon, and I also mentioned that you'd have two of the prime players in that case here, and that is Adam Aptowitzer and Kate Findlay. Adam was the person who actually argued this case before the Supreme Court, and Kate was responsible for the CCF's intervention with some colleagues at her firm. I'll tell you just very quickly, Adam is a partner and practicing lawyer at Drache Aptowitzer, and Kate Findlay is an associate with McCarthy Tétrault and an adjunct prof at Queen's. And I can also say that with both of them, we've had some very good conversations, not only about AMPs, but in Adam's case, also all sorts of areas of charity law. So both very well-informed, and I'm very pleased to have them here to tell us more about what AMPs are and what the Gandon case was about.
I think I'll begin by just discussing one of my favorite topics, and that's myself. My bio, as you read in the pamphlet, and as Marnie was saying, talks about some of my experience with charities. And of course, I'm also a tax litigator, and that's what ended up, that's the road that took me to the Supreme Court. What's interesting is that this case, while involving a charity, goes back to some rather fundamental concepts of the Income Tax Act and the imposition of an income tax. The Income Tax Act is not only concerned with, as you might guess, the imposition of an income tax, but it also involves a variety of incentives designed to encourage specific economic activity. In the past, those incentives have involved encouraging investment in, for example, Canadian film, way back when. Those of you that remember Canadian film from way back when could probably appreciate why there were incentives to invest in it. And also in certain types of multi-residential urban dwellings. And most of those programs have been done away with. And what we're left with today is the major incentive program is the donation of money to charity, money and goods to charity. Now, because there's an incentive program, what can happen when you have intelligent people reviewing this are ways to take advantage of the incentive program. And so during the 90s, and in fact before, but primarily in the 90s and ongoing until very recently, these smart individuals would devise these programs and these plans, and they would go to various individuals, Canadians, who are perhaps not well versed in the mechanics of the Income Tax Act, and they'd go armed with a 40-page lawyer's opinion, and they would say, listen, I've got a great deal for you. You're $1,000 out of pocket. Give me $1,000 and I will get you a tax receipt for $5,000. And the mechanics of these plans are not particularly germane, but essentially what it was is the $1,000 would be used to buy something at a discount, wholesale, medications, crayons, comic books, whatnot. Then, because the law allowed for the valuation of these donations at their fair market value, they would be valued at the retail fair market value of these things and donated to schools in Africa or what have you. And so at the end of the day, these people with $1,000 out of their pocket had a $5,000 tax receipt. And the government didn't like it. But the government's incentives are matched by disincentives for people engaged in the actual donation of these things. They are not, the Income Tax Act, until the provisions I'm going to discuss in a moment, did not contain any punishments against these smart people, these promoters, these designers of these programs, who would then go and sell it to the unsuspecting Canadian. So in the late 90s, out came Jack Mintz with what's known as the Mintz Report, and he had suggested that the Income Tax Act includes certain provisions which would allow the CRA, in effect the Crown, to go after these planners, these promoters of the various tax shelters, and that's what they're called, obviously, rather than relying on the traditional means of having the taxpayer sue his or her advisor for negligence in the proposal of these things. And so the Income Tax Act was amended to include a provision which allowed the CRA to assess a penalty against anybody who was either A, involved in the promotion of such a plan, or B, involved in the preparation of tax documents which, when used by the taxpayer, justified a specific tax position. And the provision is very broadly worded, and there are two sections. I'll talk about the more broad section, and that is that anybody who makes, participates in, assents to, or acquiesces in the making of a statement that is used by a third party on their income tax returns is themselves liable to a penalty calculated in one of the technical and verbose ways that the Income Tax Act likes to calculate penalties. Now, in around the late 90s, early 2000s, these plans were proliferating like crazy. And those of you that are involved in any type of criminal law work will probably know that where one person has a good idea on how to make money, somebody else is going to, some entrepreneurial thief is going to say, hey, I can do the same thing but better, and strike out on their own to do something similar. And what had happened was some of the people that were engaged in one of these tax shelter programs decided that they could do it better, took all the documents, and set up their own shop. Now, one of these people happened to be the cousin of a lady by the name of Julie Gendon. And they took all the documents, including the legal opinion, which had been issued by a well-known Bay Street firm, and provided the opinion, that is, to Ms. Gendon. They said to her, we would like you to write a similar opinion. And it was replete with all the references to all the documents they had reviewed, including, whatever there was. The tax shelter in question involved the creation of timeshare weeks in the Turks and Caicos, and of course the creation of these weeks are intangible. You can't just you pull them off a tree. You needed legal paperwork to create this bundle of rights, which would allow you to spend a week in this beautiful residence in the Turks and Caicos. And the tax opinion referred to the fact that whoever was signing it had in fact reviewed the opinion of the Turks and Caicos lawyer who had created these timeshares. Now, under duress, the cousin really pushed Ms. Gendon to sign the letter after she had reviewed it and spent some time reviewing the law. And she said, listen, I'll sign it, but I want you to have it reviewed by a tax lawyer just to make sure I'm right. She signed it, and it included the reference to, I have reviewed the following documents, one of which was the opinion of the lawyer in the Turks and Caicos that these timeshare weeks had been validly created. People then ponied up their $1,000, $2,000, in some cases tens of thousands of dollars for the purchase of these timeshare weeks, created timeshare weeks. The promoter organized everything, including the donation of the weeks to a charity run by Ms. Gendon, and she, along with one other person, and that's an important point that I'll get to in a moment, along with one other person, signed the tax receipts. People used them on their returns, and waited to hear back from the CRA. CRA gets back and says, we want to know a little bit more about this, and as it turns out, the lawyer in the Turks and Caicos never actually created the timeshare weeks. He wasn't properly instructed, all sorts of things, but there was nothing to donate. There was nothing to purchase, and there was nothing to donate. And because there was nothing to donate, the CRA's concern was the tax receipts were effectively fraudulent. And so they reassessed all of the taxpayers to say, you didn't make a donation, you owe us more money. Of course, they're out of pocket the $1,000, $2,000, or tens of thousands of dollars they had paid the promoter. So they're left effectively holding the bag. They then turn to Ms. Gendon and say, listen, you signed the receipts, some of them, and you're responsible for a penalty which, when calculated, includes not only the receipts that you signed, but because the provision says makes, participates in, assents to, or acquiesces in the making of a statement, includes all the receipts that you didn't sign but knew shouldn't have been signed, and therefore your penalty is $546,747. Wow, that was quite the day for her. And she really thought this was some sort of mistake because she, until the very last moment, thought everything was fine. Now, I'm going to skip forward through some of the preliminary arguments that were made with CRA in the process which precedes the tax court, and go straight to tax court. At the tax court, we had said, and I should go back one more point. The reason she got the penalty was not just because she acquiesced or assented to in the making of the statement, but the provision requires that the individual be engaged in culpable conduct. Now, I'm going to release a little secret. The tax court said that culpable conduct was mens rea. A guilty mind. She meant to do this. She was willfully blind. She should have known better, and she was engaged in this. So we go to the tax court, and it's an interesting process, litigation, because you start with all your arguments, including all the evidentiary ones, and by the time you're at the appellate level courts, you're down to one refined issue, maybe two. And so we started off with all these arguments, but we said that the charter applies. Now, why did we say the charter applies? We said the charter applies because the preamble to Section 11 of the charter, and Section 11 is the one that deals with the kind of procedural rights that we expect in a criminal context. The right to be proven guilty beyond a reasonable doubt, the right to a fair trial, I think is in there, that sort of thing. The preamble to that section says that any individual charged with an offense is entitled to these protections. So what does that mean? It's interesting to note that the United States and Britain, in the documents which assign these kind of rights to their citizens, do definitely use the word criminal, and we don't. And in Wigglesworth, the Supreme Court considered this and said, well, so it doesn't say criminal, therefore, there are a couple different circumstances whereby one may be entitled to these Section 11 rights, right to be proven guilty beyond a reasonable doubt for one. And those circumstances are where the provision is by nature a penal provision, and that's in addition to the kind of ones that we normally would conceive of. There is a bit of a public element test in there, which discusses whether or not the provision is part of a closed system or if it's part of a sort of general rule that is applied to society as a whole. That's to make a distinction between, let's say, the Law Society of Upper Canada or the Dentistry Association and the doctors, and let's say the Criminal Code, which applies to everyone in the same way without some elite group, I'm not referring to the Supreme Court, some elite group that sort of governs it internally. The other way one might be able to take advantage of the Section 11 rights is because the penalty is one which by its magnitude would appear to redress the wrong done to the public. Now, we ended up winning at the tax court, and we won on both grounds. The court found that notwithstanding that Ms. Gendon was wrong on the facts, and in fact was wrong even at a mens rea standard, had committed this wrong, the provision was, both by its nature and by virtue of the penalty that it could attract, one which fell under the Section 11 test. And just a quick note about about both elements of the test. The provision was originally intended to target tax preparers and tax promoters. But the way the provision is worded, and again, participates in, assents to, or acquiesces in the making of a statement, is so broad that it goes well beyond the people it's intended to target. And in fact, the appellant in this particular case was not targeted because she signed the tax opinion. That's why she was guilty, but it's not why she ended up with a penalty this high. She ended up with a penalty this high because she was involved in the signing of tax receipts as the designated representative of the charity. And similarly, the provision could be used when you go to get in a cab and you ask the cab driver for a receipt. quite often, I won't say in all cases, but quite often he just hands you a little card and you fill it in yourself. You walk away, you fill it in yourself, and you could attach that to your tax return and use it as evidence of a deductible expense. In that case, the taxi driver could be responsible for acquiescing in the making of a statement. Taxi driver, a wait staff in a restaurant could do the same thing. In that case, it's filling in the tip, and then you attach the total cost to your tax return, and you attempt to deduct the tip. So this is an example of the fact of the broad reach of this provision. And on the other side, the Crown was arguing to say that, well, the Income Tax Act is really this closed entity. The fact is, this all relates to the collection of tax. Now, you can see from the way I framed the argument that clearly they're wrong. I think the judges may have something else to say about that, because I'm sure that the Crown lawyers framed their argument a lot more fairly than I'm doing now. But fundamentally, they're saying, look, it's in the Income Tax Act. This deals with the collection of income tax, and therefore it's constrained. Tax court agreed with us. The Federal Court of Appeal agreed with the Crown. On the question of the penal provision, there is a nominal type of limit in the Income Tax Act to the specific penalty which one may draw. That penalty is $100,000 or a relation to or a penalty calculated in relation with the understated tax. But that penalty is $100,000. My client was facing $550,000 penalty. How could that be? Well, because she had signed or been responsible for 130 odd receipts. And so the question became whether or not the additive amounts, so that it was effectively limitless, is what counted, or was the fact that the penalty on each particular provision was limited is what the courts need to look at. Again, the tax court agreed with me, the Federal Court of Appeal agreed with the other side, and now we're at the Supreme Court. So we argued the case December the 5th. There was an ancillary issue, which I'm going to bring up now in case anybody reads the decision, on whether or not notice of constitutional question had to be served. And this is a technical matter which I don't propose to get into now. I do hope that the court will look past that in order to render their decision. But it brings up interesting questions, because these monetary penalties, if the court decides that the charter does not apply to penalties such as the one that we argued in the courts, then prosecutors have a really wonderful means of proceeding with a charge. When a prosecutor looks at a charge, they get to decide, and they say, all right, well, do I or don't I want to seek jail time? Let's say they make the decision they don't want to proceed with jail time. If that's the case, then why on earth would they want to proceed with a process which grants the accused rights, charter rights, and the right to be proven beyond a reasonable doubt? Why would they not simply proceed with a monetary penalty provision, which, if the court opines on in favor of the Crown in our case, means that the charter doesn't apply, and they can end up with a similar penalty, in some cases, in our case, as we calculated it, a little bit more than what the minimum criminal penalty would have been. Why on earth would they make it more difficult for themselves? And I should point out that the criminal tax evasion provision is very similar wording. It participates in, assents to, or acquiesces in, very similar wording to the penalty that we were dealing with. So in the first scenario, the prosecutor gets to decide, well, I'm going to go on vacation. Let's just make it an easier burden on myself. I'm just going to pursue the financial penalty, not the criminal penalty. And we should point out that the financial penalty doesn't have the same kind of sentencing guidelines and determination of the penalty that the criminal one does, which may be a difficult point for the court, because sentencing guidelines typically are part of the criminal regime. They're not part of this administrative monetary penalty regime. So that would be the first thing. The second thing that a prosecutor could do is let the CRA proceed with its investigation. It goes through the investigation, and in its bumbling, it breaches the charter rights of the individual. Well, that sucks, but not for the prosecutor, because the prosecutor gets to decide and say, well, you know what, I didn't intend to breach your rights, but because they did, I'll just do what I was going to do before, and I'm going to get a ruinous financial penalty, and you know, good luck to you. And I think that really frames these administrative monetary penalties. It frames our case, but what it doesn't do is it doesn't tell you how that applies in a broader sense, because these administrative penalties are occurring in legislation in every province in all sorts of acts, securities, environmental, telecommunications, and that's okay. Don't worry about that, because that's what Kate's going to do. She's going to fill you in on how things look from a more global perspective. And my intention was to fill you in on how it works in this case, and specifically with the income tax act. Thank you very much.
So Adam's spoken to you about the Gandon case and administrative monetary penalties in the Income Tax Act. As he said, I'm going to speak more broadly about AMPs that really over the last 20 years have been incorporated into both provincial and federal legislation across Canada. Gandon stands out in part due to the size of the AMP levied. However, the reality is that AMPs can affect all Canadians. In a matter before the Agricultural Review Tribunal in 2012, a woman was levied an AMP of $10,000 due to the alleged importation of a horse from the US without a certificate properly approved by the US authorities. In a matter before the federal court in 2013, a man was levied an AMP of $18,000 under the Health Animals Regulations when, upon returning to Canada from El Salvador, he checked the no box on his customs declarations form when asked whether he was importing meat products. And his luggage was later found to contain 15 pieces of fried chicken that had been put there by his mother, unbeknownst to him. It serves as a lesson to all of us that AMPs can affect anybody at any time. AMPs are attractive to regulators for several reasons. They fill a gap between traditional administrative remedies and criminal prosecution. The burden of proof is the civil standard of the balance of probabilities rather than the criminal standard of beyond a reasonable doubt, making it easier for prosecutors to levy an AMP than a criminal fine. Administrative proceedings where they exist are also shorter and less costly. For instance, pre-hearing proceedings may be lesser as the Stinchcombe disclosures are often not required. Finally, no criminal stigma is attached to a fine being levied, or often there's a lesser criminal stigma. For this reason, corporations are more likely to agree to a settlement with respect to an AMP than they would with respect to a criminal fine. AMPs have become pervasive throughout provincial and federal legislation over the last 20 years. The most controversial AMPs are those with a high monetary value, those where the maximum AMP is equivalent to the maximum criminal fine under the same piece of legislation, and those where the maximum AMP is in fact higher than the criminal fine under the same piece of legislation. To give you a few examples of particularly high AMPs, we can look to the Ontario Compulsory Automobile Insurance Act and the Ontario Insurance Act, which carry AMPs of $100,000 for individuals. The Competition Act carries an AMP of $750,000 for individuals for a single contravention. And the Ontario and Alberta Securities Act each carry AMPs of $1 million for individuals for contraventions. There's also multiple examples of instances where the maximum AMP is equivalent to the criminal fine under the same piece of legislation. These exist in the Customs Act, the Railway and Safety Act, the Alberta and BC Lobbyists Act, and the Ontario Automobile Insurance Stabilization Act. The problem where AMPs and criminal fines under the same piece of legislation are equivalent is that the burden, as I said, is lower for AMPs. There's less administration associated with pursuing an AMP. And so when faced with a choice where the fine is the same, regulators are much more likely to go the course of prosecuting in accordance with an AMP and thereby denying the accused their Section 11 charter rights. It's an easier job. There are also several pieces of legislation that exist where AMPs are in fact higher, significantly higher, than the equivalent criminal fines under the same legislation. In the Competition Act, the AMP for deceptive marketing, so promoting false and misleading representation, is $750,000 for individuals, whereas the criminal summary conviction fine is only $200,000. In the Private Career Colleges Act, the AMP for contravention of the Act is $250,000 as opposed to a criminal fine of $50,000. The Canada Shipping Act and the Ontario Water Resources Act are also similar examples where the AMP is higher, and in fact is many times as 5 times higher than the criminal fine under the same piece of legislation. Adam spoke briefly about Wigglesworth, which is where the test comes from, which determines whether individuals should be afforded Section 11 protections in relation to AMPs. Wigglesworth held that Section 11 rights are limited to persons prosecuted by the state for offenses involving punitive sanctions, and individuals are afforded Section 11 rights in 2 circumstances. One, where by its nature the matter appears to be a criminal matter, and 2, where the matter has true penal consequences. Under the second part of the test, there's an assessment of both the magnitude and severity of the fine or punishment, which affords Section 11 rights where by the magnitude, the AMP appears to be addressing a wrong to society rather than simply a deterrence effect. The second step is the only operative branch of the test for administrative proceedings, and so has heightened importance. Unfortunately, the jurisprudence that we have seen come down has really watered down this test, where it's virtually impossible to meet for AMPs. Now most Section 11 challenges to AMPs are dismissed because the AMP is found to fulfill simply a deterrence effect and thus not meet the true penal consequences test. I'm going to briefly discuss the key cases in which Section 11 protections have been sought in relation to AMPs. First is Lavallee, which is a 2009 decision from Alberta's Queen's Bench. The staff of the Alberta Securities Commission had commenced regulatory proceedings against the applicants for alleged breaches of the Alberta Securities Act. Sanctions included an AMP of $1 million per contravention. The applicants applied to the Court of the Queen's Bench for a declaration that the AMP was subject to Section 11 of the Charter on the grounds that they faced true penal consequences. Justice Whitman found that it was not the impact of the potential consequence on the accused, but the purpose of the sanction, which determines whether a sanction constituted a true penal consequence. The court held that there were no penal consequences present in that case. The Alberta Court of Appeal affirmed Justice Whitman's decision, and leave to appeal to the Supreme Court was denied. The second case is U.S. Steel, which is a 2010 decision of the federal court, and it concerns a dispute between U.S. Steel and the Government of Canada regarding alleged breaches by U.S. Steel of undertakings given pursuant to the Investment Canada Act. The potential AMP in dispute was one of $10,000 for every day in which U.S. Steel failed to comply with the Attorney General's demands. And this, in fact, stretched from November 1st, 2008 until the first decision of the federal court on June 14th, 2010, with the result that U.S. Steel was facing an AMP of over $6 million by the time the decision was rendered, which continued to grow over subsequent appeals. U.S. Steel characterized the AMP in dispute as a King Kong fine and said that due to its size, it was entitled to protection in accordance with the Charter. Justice Hanson found against U.S. Steel and held that the magnitude of the size of a monetary penalty alone was not sufficient to conclude that the penalty had true penal consequences. The Federal Court of Appeal affirmed Justice Hanson's decision, and Justice Nadon found that broad discretion granted under AMP provisions was not objectionable, as the court retained the discretion to impose a lesser sanction. The last case I'll mention is Rowan, which is a 2009 decision of the Ontario Securities Commission. And this is a case where the respondents were sanctioned for breaches of the Ontario Securities Act, and regulators sought to impose penalties between $300,000 and $1 million for individual respondents. This was challenged by the respondents on the grounds that it constituted, again, a true penal consequence. Similar to Lavallee and U.S. Steel, the panel stated that notwithstanding the magnitude of these fines, that the primary purpose of AMPs, the AMP in this case, was the protection of investors and specific deterrence, such that the AMP did not have true penal consequences. The panel also found that the AMP had no criminal characteristics because there was no criminal record associated with it, and accordingly, it really was not penal in nature. The panel also found that to the extent magnitude is considered, assessment should be for the actual AMP imposed as opposed to the theoretical maximum in accordance with the Act. The decision was upheld by the Divisional Court absent further reasons. I'm going to now turn to discuss three of the largest problems with AMPs, with the AMP regime as it currently stands, which is the size of the fines, the burden of proof, and the retroactive application of AMPs. While some smaller fines exist throughout different pieces of legislation, there are not an insignificant number of AMPs which have associated with them large fines, which are ruinous for both individuals and corporations. When we look at the AMPs levied pursuant to Section 163(2) of the Income Tax Act, as was done in Guendon, we see that of the 48 times AMPs were levied pursuant to the Income Tax Act between 2009 and 2013, the median fine in all those cases was $440,000, demonstrating that the fine levied in Guendon was not unique. I've spoken already about the significant fines that have been levied against individuals and corporations in a variety of pieces of legislation. In many cases, above $1 million in some cases. These fines are ruinous for individuals and corporations, and it defies logic in many cases that they can be levied without proper charter protections. Fines can also be ruinous where the multiplier effect exists. So where fines are levied over multiple days, as in U.S. Steel, or where AMPs are levied for more than one contravention. While the AMP in Guendon may not have been ruinous had there been a sole contravention, as we know, there were 135 instances of Ms. Guendon writing income tax receipts such that the fine was much elevated. Similarly, in U.S. Steel, while a single day's fine of $10,000 may not have been ruinous, when it amounted to $6 million over the course of the dispute, that ended up having a significant effect upon the corporation. Given the size of AMPs and the reality that the financial penalty of this size, in effect, has penal consequences, logically it seems that persons levied AMPs should be afforded charter protections. I'm going to turn now to talk about the burden of proof. As I discussed earlier, the burden in criminal cases is that of beyond a reasonable doubt, while the burden in civil cases, and applicable to AMPs, is the balance of probabilities. However, there are several differences between civil cases and AMPs, such that this burden is arguably not appropriate for AMPs. First, there's more stigma attached to a finding that an individual has violated a statute than a civil finding that an individual is liable for damages to another party. Second, AMPs are arguably more serious as they involve the government power to penalize, whereas civil cases do not. Third, civil cases compensate, whereas AMPs in effect punish. Only punitive damages punish in civil cases, and as we all know, those are granted only in extraordinary circumstances. There's precedent elsewhere for a higher burden to apply with respect to AMPs. In the UK, they have the Regulatory Enforcement and Sanction Act, and this carries with it a standard of proof of beyond a reasonable doubt that is used for fixed monetary penalties and discretionary penalties. This act also allows for administrative procedures involving written submissions and appeal mechanisms that could afford more security to persons in Canada where they afforded here. Finally, AMPs are often applied retroactively. While the criminal law is clear that the law applies as it existed at the time of the offense, the situation is less clear in administrative law. Following the addition of AMP provisions to Alberta's security legislation in 1999, the Securities Commission in Morris & Williams Investment Management held that it could impose an AMP for conduct that predated the enactment of the AMP provisions. In Brost, a 2005 decision of the Alberta Court of Appeal, the court confirmed the decision of the Alberta Securities Commission that a new maximum AMP penalty could also be applied retroactively to conduct that took place before the maximum AMP penalties were increased. I'm going to turn now to a discussion about potential reforms for AMPs. The Honourable Todd Archibald, writing an obiter, has made several suggestions for the potential reform of the AMP regime. First is that AMPs be capped at a moderate level to minimize the damage from the possibility of a wrongful finding of a violation. The second is that no increase in the cap for subsequent violations take place. And the third is the suggestion of the creation of separate categories of penalties, all falling below those caps. So turning to the notion of a cap. Justice Archibald has suggested that a $10,000 cap for individuals and a $100,000 cap for corporations would not require charter protections. This position was echoed by the CCF in its submissions as intervenor before the Supreme Court in Gandon, where the CCF argued for a cap of $10,000 for individuals and $100,000 for corporations, or less than 50% of the maximum fine under criminal provisions of the same statute. The CCF also argued that the presumption of true penal consequences for anything beyond that cap be rebuttable if the penal consequences can be shown to be merely incidental. And CCF argued that this approach creates bright lines and satisfies the need for predictability and clarity. Justice Archibald argues that this cap recognizes that a balance of probability standards can result in the possibility of a wrongful finding of a violation, but minimizes the potential financial penalty associated with that. Justice Archibald also argues that this puts the appropriate dollar value on the moral harm associated with a violation. Second, Justice Archibald suggests that no increase in the cap exist as a result of subsequent violations, creating a distinction between monetary penalties and punitive criminal fines. The notion that AMPs are not punitive has origins in the view that AMPs are a price rather than a sanction. Sanctions increase with the need for deterrence based upon an actor's state of mind, whereas a price is directly linked to external harm caused by the act and is not linked to an actor's state of mind. A parking ticket is a price. If you park in the same illegal spot every day, you get the same ticket. State of mind's not a factor. In contrast, drunk driving and other criminal acts are enforced by sanctions, which increase with continued violation and are linked to a state of mind. The theory is that if AMPs are not to have penal consequences, they should be modified such that they represent a price rather than a sanction. And the penalty associated with subsequent violations is equal to the first violation. Finally, Justice Archibald suggests that separate categories of AMPs should be created in proportion to the gravity of potential harm. So different categories of penalties with hard caps between each would exist, all below the $10,000 cap for individuals and the $100,000 cap for corporations. So that's a brief overview of where the discussion regarding AMPs stands today, at least until the Supreme Court releases its decision in Gandon. And with that, I'd like to remind you to check your luggage for a fried chicken, and I think we'll turn it over to questions.
Hey, I want to identify a potential tension between the size of the penalty and the potential and the procedural protections that go with it. So, in a lot of these cases, we're dealing with instances where there are potentially big gains to be made from violating the rules, and often a low chance of being caught. So, in the tax evasion situation or in securities. And so for that reason, you need a sufficient deterrence to get the behavior that's desired out of it. And if you increase the procedural protections, you decrease the chances of being caught, which means that to have the same level of deterrence, you have to have a higher penalty. And so it seems to me that the suggestion of lower penalties and greater procedural protections are sort of in tension. And so the question would be, is it better to have high penalties and high protections with the potential then that you have a disproportionate penalty? Or is it better to have a balance of probabilities with a more moderate penalty, same level of deterrence?
I don't know why you can't have both. Why can't you have a high penalty and in those circumstances get the benefit of charter protections, and when there's a low penalty, you don't? And but admittedly, it's a tough line to draw, and I'm sorry I didn't make that point before. But how do you draw that line to say this is where the charter will apply? This is when it becomes an offense, as determined by Wigglesworth, when discussing simply the question of the size of the penalty, and this is when it's not. And I think that when Kate cited Justice Archibald saying, "Hey, 10,000 or 100,000," I mean, he's throwing a dart. I mean, he should say, "Look, maybe it's this, maybe it's not that." But I think But I don't see any reason why we couldn't have both.
Well, actually, you'll just have to allow me to make a comment instead of really ask a question, since there's nobody on the floor wanting to ask a question. Well, I'm not good at pretending stuff. Like when I asked Clark Neely like whether he is that blunt before the court, I mean, I really did want to know that because, well, Kate has accurately described what we finally settled on for the CCF's submissions in the Gandon intervention. I mean, my position is that Wigglesworth is, to use a polite term, bullshit. The whole Wigglesworth case is wrong. I mean, the line really is any offense. That is, any time where the state says we're going to compel the individual to do something against his will, and if he doesn't, we are going to take either his time or his property. I mean, in my view, that should trigger all the protections. That's where I would draw the line, and I think that's the philosophical problem we have with it. Like Wigglesworth was really a bad case because it didn't make that distinction. Anytime that the state says we're going to take your property, in effect they are saying we're going to take a portion of your life, because we're going to take retroactively take the portion of your life that you spent earning that property. It's just as if we put you in jail during the time that you earned that property. And so in my view, taking your money is tantamount to taking your liberty retroactively. So, I mean, that's the argument that I would make. I know it's way too radical to ask McCarthy's to make that argument. But essentially, all of these things, in my view, unless they are crimes under the criminal code, which genuinely do tend to be crimes with victims, all of this regulatory stuff is victimless crime. The state wants you to do a certain thing, and it can't show that there is a victim, so it imposes these penalties because it wants people to act in a particular way. But most of this stuff is, victimless offense. They just want you to do it their way. It's them saying this is what you have to do. So that's why I draw the line at, any time the state exercises coercion in the form of a penalty, then those protections should apply.
So as a layman, I'm really shocked by this retroactive penalty business. Have there been any constitutional or charter challenges to that in the past, or are there any CCF plans to challenge that in the future?
Most of the cases seem to have been in Alberta that I've read, but I'm sure I haven't followed it extensively, so I don't have a full answer for you on that.